Hello, it's Joan the Liberty Lion, and today we're going to talk about contracts, trusts, contracts with infants, and love and affection in contracts. Okay, so we're going to start off with contract drafting and negotiations for entrepreneurs and business professionals. So there's a belief among a lot of people that are in my circle that believe that you cannot contract with an infant. And to some extent, this is true, and to some extent, it's not true. So you cannot really contract with an infant because a contract, to be a contract, must have rights and obligations. But you can contract for an infant. So not with, but for an infant. Um, so in this book, Contract Drafting by Paul Swegel, he says that under consideration, another important word, that said contracts citing $1 or love and affection in exchange for goods and services of measurably higher value might not survive attack in some states. Okay, so love and affection is an important quote as far as trusts go. So when you're contracting for an infant, you're giving the obligation part of the contract to someone else, but the benefit, all the rights and the benefits go to the infant or the beneficiary. So a lot of times, I find that people are not paying attention to the exact wording when people are talking, and so they say you can't contract with an infant, and then they say that all contracts for infants are null and void because you can't contract with an infant. True, but you can contract for an infant for the benefit of the infant, but given the rights and obligations portion to a trustee, which then makes it a trust. So under 76 American Jurisprudence, second edition, um, section 1, where they talk about um, the definition of a trust, it says in the first two sentences, the trust is a very comprehensive institution. And the second sentence is, it is as general and elastic as contract. Okay, so a while back, I had found a dictionary that had the definition of legal and then right under that, legal age. And so when you read the definition of legal, sometimes it's hard to decipher exactly what these definitions mean. But if you went under that and you saw the definition of legal age, it was quite a bit more telling as to the intention of what legal meant. So under legal age was basically the age which a person must be in order to create legal relationships, or in other words, in order to contract, to make contracts. Now, there are some instances where, with a parent's permission, a child under 18, age of majority, can contract. And that would be for going into the military early, um, or getting a driver's license, or some other things, right? So we're going to talk about now some of these words and what they mean, and um, the love and affection part of a contract and why that's so important. Okay, so in 76, American Jurisprudence, second edition under trust, subsection 76, sufficiency of particular forms or types of writings, under their note, um, this would be 90, I think. It says, where further or where father, by verbally promising to give land to son in consideration of love and affection, upon condition, now this son is age of majority, upon condition that son makes certain, okay, consideration of love and affection, upon condition, so that's the obligation, that son makes certain improvements within a specified time, put son in possession, and latter fulfilled conditions precedent, son thereby acquired equitable title, equity regarding father as trustee for son, and the latter's possession conveyed notice to the world of his equitable title and of his son's right to legal title. Okay, so once the son satisfied the obligation of improvements, the son inherited his equitable title because he has put work into the property, and his legal title so the world can see that he is the legal owner of the property, equal with his father. So the love and affection portion of it is from father to son because the father is giving it to his son. So it doesn't matter if it's a son or a daughter, or from mother to daughter, or son to father to daughter or son. It's the love and affection part that um, is the idea that this is done for the benefit of his offspring, his kin, his love and affection for his child, to share the equity of the property. So in family trust, they talk a little bit more about love and affection. And of course, I've read the contract drafting. So when you have a child underage and you're uh, contracting for the benefit of someone else that's underage, you're not contracting with the infant. So the infant doesn't have obligations. Um, but the infant has the benefit. So once the infant comes of age in a trust, for example, this book by James E. Hughes and some others, Family Trust. I think he's like a seventh generation trust attorney in New York. He talks about the obligations the child or the beneficiary has to fulfill once they come of age. For example, he doesn't require it, but he says that some of the requirements that a parent may want to put, or a trustee or grantor may want to put in a trust, is, for example, so many years of military service, or some years doing philanthropy, or helping the homeless, or running a nonprofit organization or something like that. So it's not like you turn 18 and you just get all this money, because he finds that when you do that, you end up with children who squander all the money. And if they squander all the money, then there's no money for the third generation. So they call it shirt sleeves to shirt sleeves in three generations, because the third generation, there's nothing left. Or after the third generation, there's nothing left because there's nothing in the trust that goes beyond placing requirements on the third, fourth, or fifth generation. So he talks a lot about writing trusts. Another book of his I've read, and I think he has several other books, is Family Wealth. And he talks about keeping your wealth in your family and how to do that. And for example, one way is the use of the 401ks to take out a loan. That way, when you pay the loan back, you are paying yourself because the interest goes back to your 401k. And there are other ways to do that, but that is not the purpose of this video. This video, we're talking about contracts and trusts. Okay, so this is from Family Trust. Sorry, you can't really see that, but it's a guide for beneficiaries, trustees, trust protectors, and creators. There's a website. I should have mentioned this before. www.wise, W-I-S-E, counsel, C-O-U-N-S-E-L, research, research.org. I know I went to that website a long time ago, but I don't remember what's there right now. But if you search for James E. Hughes Jr., you can find some of his books. I think he's got a website online. They're also on Amazon. So I'm just going to ruffle through these pages a little bit and tell you some of the stuff that he says and explain a little bit about why he says it, but I think you'll get the gist of it. So in all my reading, I come across things here and there, right or wrong. I draw on all of this information, or I should say correct or incorrect. I draw on a lot of this information to try to put together in my head my own beliefs on things. And so some of the stuff that I've read says that there are certain things that the government or any government can regulate, and then there are other things that they cannot regulate. So, under our constitutional law, one of the things that the government doesn't regulate is religion, right? They don't tell you you have to be a religion. They don't tell you what religion to be. They don't tell you you have to believe in God or not believe in God or a higher power or whatever. So along that line of the realm of natural law, and one of those being religion, are just any of your belief systems. The government cannot regulate your belief systems. They cannot regulate nature or natural law. They can't regulate love, affection, who you choose to have a family with. So relationships. So there are natural relationships and then there are legal relationships, just like there can be a legal portion of a document and there can be a natural portion of that same document. And that's basically what he's saying as far as trusts go, that there are things that you can write in your trust that remove certain aspects of it from the jurisdiction of a legal court or legal system. And again, he's been doing this for his whole life, but his family has been doing this now. He's the sixth generation, or I'm sorry, I think he's a seventh generation. So one of the things he says in here that's important in a few minutes is the single most important reason for creating a trust. So when he says the single most important reason for creating a trust is this is what you want to put in it. This is why creating a trust is important. So don't forget to put this in your trust. That's the way I read it. Is to make a gift that promotes the beneficiaries true freedom. So one of the other things I've read is that, not in this book, but somewhere else, is that to be able to experience true freedom, you have to be able to live a life of leisure. So once you retire, you're considered a life of leisure, and that's your true freedom. So the way this system is set up that we live in today, in America anyway, is that you're not allowed to experience freedom until after you retire. That doesn't mean that that's the only way to do things. Another way to do things so that people can experience true freedom is through trust. Of course, not everybody can create a trust, not everybody has the money to create a trust, but there are things that people can do to enhance their freedom. It says enhance here has various meanings, but all of them are positive. Specifically, we mean a type of enhancement that helps the beneficiaries mature and come to know and pursue their own aspirations. So, a life of leisure is what I read before. And I think what he's saying is that true freedom is not just laying around and doing nothing and just being leisurely all day, but to also be able to do things that you enjoy doing. And that when you can do things that you enjoy, that is true freedom. So, like Elon Musk, for example, he has so much money, he can do whatever he wants. He can lay around all day and just have a life of leisure, or he can work. He likes to work, and he says gets so many ideas, and he does all these things, and he has these companies, and that's what he likes to do. And that really is true freedom. He can do all those things that he likes to do. So, as I mentioned a few minutes ago, that a trust, this guy says, James Hughes says that a trust should not allow someone to just do whatever they want and never have to do any work, because that creates basically a narcissistic type of person. They really don't have to work for what they have, and they end up spending it all. So even if you put an amount on it, what they'll do is they'll just lay around and spend it all and generally be um, an a-hole in society. And he says that's not good for the kid, and it's not good for the lawyer trying to manage the trust, and it's not good for the parents if they want to have a productive child who understands how the world works and can get along in society. And that's why he says one of the things that you should do in a trust is put the stipulations in so that the child, when he comes 18, he has to join the military or work for a nonprofit or start a nonprofit, some other thing, so that they're just not sitting around all the time just spending money. And of course, he talks about addiction and how the parents should put something in the trust that allows the lawyer to withdraw giving the child money if they're suffering from an addiction. So even their basic needs cannot be met. So you might find someone out on the street who says, "Well, I'm a trust fund baby, but I can't get the trust money because I have addiction issues." You might come across that some point in time. Maybe you have. And that's the case that he says for writing these trusts. Otherwise, they're just a draw on the trust, and they amount to basically nothing. So when you have a child, of course, you want the best for them. And so the trust should have a spirit. The spirit should include certain things. So that way you're taking um, your desire for your child's um, good life to not just be laying around and running all over the world and spending all the money, but actually doing things to enhance their life, but enhance society also. And if they can't do it, they don't get the money because that's not within the giver's spirit. Okay, so he talks about taxes, which would be the legal aspect, and to do no harm, and that when the beneficiary receives the money, the beneficiary cannot do harm, but also when a court steps in and says, well, the trustee did something wrong and the trustee is being sued, we're going to take all the money from the trustee that is actually belonging to the beneficiary. Well, that can't happen. So if the trustee gets sued, it doesn't come out of the trust because it's not the trustee's money. So if the trustee actually has money and they put it into the trust, then they're the grantor and the trustee, but that money's safe because the courts can't do harm to a beneficiary. And then we go back to the biblical law, I think it is, that no harm can come to a child because of what the parents might have done. Okay, and then again, we go back to that natural element of love and affection, a lawful purpose, a natural thing, the gift of freedom and the gift of the spirit of the trust giver. Oh, no, I don't have to go there. Okay, so the trust giver. Um, so let's see, he talks about in here. So, like I said, I have to sort of go through this, see where my stuff is. I think it's here. Okay, so a trust is properly viewed as a relationship among trust creators, trustees, and beneficiaries. So you have a legal relationship, and that is when the beneficiary becomes of age, and then you have this contract, which is a legal contract, and you have the trustee has to be of age, the grantor has to be of age, the beneficiary has no obligations. They don't have to be of age until they do become of age, and then they might have obligations. And then you have the spirit, the freedom, the love, the affection, and that's the natural, lawful purpose of the trust to convey a spirit. So the trust should include the giver or the grantor's spirit of what he wants the beneficiary. So he wants for the beneficiary. So if I have a child and I am hoping that my child will get a PhD in anything, then I would say, well, I'll pay for their college and I'll pay for cost of living to some extent. And then once they get a PhD, then they can have more of the trust money. So it wouldn't be like, I'm just going to just give you everything when you turn 18 and then you're just going to run around and spend it all, because that's not the spirit. That's not what I want for my child. I might put in the trust, well, I don't want to give money to an addict because I don't support being an addict. So if the child becomes addicted to whatever is in the trust, then I might say, well, I'm going to give them 2 or 3 tries at counseling, addiction counseling. And if they can't get their shit right, then they're out. They don't get anything, because that's not something that I want to promote for society. I might say, the spirit I want for my child is to be a productive person in society, or a person who is social and gets along with society and obeys the rules and stuff. So just like veterans benefits is a type of trust. So if a veteran ends up in prison for certain crimes, they lose their veterans benefits. Okay, so the only person who appears in the 4 legally required elements of a trust is the beneficiary. Okay, the beneficiary, not the trust creator, who may be long gone, or the trustee, is the single most important person to the existence of a trust. No beneficiary, no trust. So it's all about the beneficiary. Okay, so the trust creator's intent. So what does the trust creator want for the beneficiaries? And hey, if you don't want to join the military, you don't want to be a productive person, you want to get on drugs, hey, that's fine, go ahead. But you're not getting my money. Not that I have any money, but if you were to create a trust. Okay, the answers are your treasures. So you do these things, you get you get the treasure. Let's see, there's a couple other things. Okay, so he talks about individual, natural person, and the individual or natural person can, or individual is the natural person, can serve as a trustee. That person may be a professional or a layman. Um, I'm trying to figure out what he means by individual, if he means that the individual is a natural person, but of course, in some legal documents, some legal books, they talk about individual as a group. So when a group works as an individual, and maybe that's what he means, if even if it's an individual trust as a with natural law in it, then he may be saying that the group is like the family, and then the family is natural, and the family working as a, what did he call it, an institution. In American Jurisprudence, second edition, number 76, 1, the trust is a very comprehensive institution, a general and elastic contract. Okay, let's see. He talks about do no harm in the trust. The beneficiary has to engage in a noble profession, something good. Can't just run around doing drugs and traveling the world, spending money, and generally being an a-hole. The manner in which a gift is given determines the manner in which it is received. And that was by Seneca, a Roman philosopher. He says, distinguish between transfer and, here's our love and affection, gifts with spirit. Okay. The cycle of the gift. Also, every gift contains within it some sort of spirit or message. As we have mentioned, the message may be one of control or even contempt. It may be a spirit of freedom, encouragement, and love. For trust creators, we ask, what is your meteor? The beneficiaries, we ask, what has your meteor brought into your world? What do you want to bring into the world when you create a trust? What what do you want to see happen with it? What are my dreams? Okay, it involves gratitude, thank you. Um, what kind of people do you want to promote for the world? He says, only the individual trust creator can decide whether he or she is ready to make a responsible gift, a gift with spirit in the form of a trust. Our experience is that most of us are not ready, even when we think we are. Taking this step may take a great deal of time and deliberation. It's not something to hurry along because of perceived deadlines due to changing tax laws or the like. Because he says somewhere in one of these books that I read that some of the really wealthy people will go to, like, Trump, whenever he did his first 4 years in office as president. He went through and he changed the tax laws and made them more beneficial for trusts. And a lot of people, their trusts are good for 99 years. It's called Law of Perpetuities, which I think has been changed since he wrote this book. But um, the Law of Perpetuities says how long a trust is good for. And so people would do the max. And because when they create their trust, they're under the law, the tax law created during that trust. So during the creation of that trust for that time. So if you renew your trust during a time when trust tax laws are more beneficial to trust, such as during Trump's first administration, then you renew during that time. And then for the length of your trust, it's good for those tax laws. So even if your trust expires in 100 years, you're under the tax laws of 100 years ago. So just think in 1925 what the taxes were. And then in 2024, when those trusts came due to be renewed due to the law of perpetuities, they renewed, and then they come under the tax laws for that time. So in 100 years, when taxes are heavy, um, the trusts that have to be renewed will come under the tax laws for 100 years back. So you think about how money works and everything, and then you'll be making money and over the years, the next, well, 99 years, I guess. So the reason why I think it's 99 years is because there's something with 100 years where if something lasts for 100 years or more, then that's the law set in stone. So they have to make a law of perpetuity saying trusts have to be renewed for at least every 99 years. So there was something that Ron Paul said that caught my attention. He said something like, marriage laws are the only laws that, I'm not going to get this exactly right, so it's not a quote, but he said something like, the marriage laws are the only laws that can be changed during the time of the contract. So if you get married in 2000 and the laws change in 2005 and 2015, then your marriage contract is under those new laws. Trust laws are not, because like he said, marriage laws are the only ones that change and apply to the contract, the marital contract, no matter when you got married. You come under whatever new laws passed. So now we're going to talk about a few other things in the next section. I think I have some things to do, and so I'm going to come back, but no worries, because this will all be one video. Okay, so this document is an article by the Harvard Law Review on trust law and expecting the worst by Elizabeth F. Emmons, 133 Harvard Law Review, 1963. Okay, so he says, he gives a few examples, and then or she explains what this means as far as love and affection and those kinds of things. She says, a man says he'll marry a woman while he is secretly involved with someone else, just long enough to get her brother's kidney. The couple sets a date, a kidney transplant takes place, and riding home from the hospital, the groom to be announces the engagement is indefinitely postponed. A year later, he marries the other woman. An American woman meets a Soviet man on a cultural exchange program, and after he professes his love and proposes, she marries him. She spends the next 3.5 years working to help him immigrate to the United States, paying $15,000 in expenses and dedicating approximately 20 hours per week to his immigration admin, delaying the completion of her doctorate and thus diminishing her income. After her husband's successful immigration, she learns that he lied about his feelings and intentions. He was merely using her as a conduit to legal immigration. An 18-year-old girl is in a debilitating car accident and spends the next 2 years recuperating in her parents' home. During that time, she receives a $63,000 settlement check from the driver of the car, which she entrusts to her father. Contrary to her mother's report that the money is, quote, being held in an investment account for her benefit, end quote. The daughter learns later that her parents had spent $30,000 on themselves. which was the entire sum remaining after paying for her medical bills and a car. These plaintiffs' accounts populate the pages of Professor Jill Hasday's Intimate Lies in the Law, and like most of the plaintiffs discussed by Hasday, they lose in court. Not all of the book's plaintiffs deserve to win. Some of the cases invite debate. Consider the young woman whose parents spent the settlement from her car accident. Even by her account, she waited 9 years after moving out before asking her parents about the money. Her mother denies ever saying the funds were being held in an investment account, and her father says he understood the remainder after paying for her car and medical expenses to cover the reasonable cost of her room and board. Debating these cases could make for lovely Thanksgiving dinner conversation or exam hypos in torts or contracts. Hasday argues that many of these plaintiffs should, however, be winning or at least have a chance of winning, which they would, she contends, if courts were treating these claims the same way courts treat deception by non-intimates. Courts not only dismiss cases involving intimate deception, but sometimes overturning substantial jury awards in a plaintiff's favor, but also chide duped intimates for not being more savvy, for not being vigilant enough to detect the deception. I told y'all I keep my Amber Alerts up. Let's see. These courts seem to blame plaintiffs for trusting those they love. One woman whose husband lied to her to hide his bigamy, financial misdeeds, and more is quoted by Hasday as lamenting, "I trusted him, I believed in him, and yet I am branded stupid for doing so. On top of losing everything I own and facing a future raising 3 children on my own, it's hard to know that society as a whole views me as a kind of fool." Trust emerges as a potent subtheme in the book, but one which is incomplete. In this review, I turn squarely on the subject of trust, drawing on sources from psychology, philosophy, management theory, literature, and diverse areas of law. After exploring dimensions of trust, I build out a framework that combines affective trust, a feeling of safety, and cognitive distrust, a willingness a willingness to doubt and inquire, later reframed as epistemic curiosity, a drive to know. Approaching intimate relationships with both affective trust and epistemic curiosity is no easy feat. An appreciation of this, I argue, helps us to understand better Hasday's proposals for reform, as well as to spur further legal innovations. This review has 3 parts. Part 1 aims to convey something of the breadth and interest of Hasday's fascinating new book, foregrounding the role of gender and beginning to touch the subject of trust. Part 2 delves briefly but widely into the theme of trust, which pervades the book and invites further examination. Part 3 presents a framework that combines affective trust and epistemic curiosity and applies this framework to illuminate and sort Hasday's proposals for reform, to critique a recent dramatic change in the evidentiary treatment of marital confidences, and to devise a novel approach to prenuptial agreements. Because remember what I said, that Ron Paul had said that the marriage contract is the only type of contract that can change throughout a marriage. So you can be married for 20 years and the laws that govern marital law could be changed and still affect that marriage that happened 20 years ago. So he says, throughout this review aims to engage and inspire the reader's own thinking. Together, we'll make it worth your time. Trust me. Okay, so I don't have that. I just have this, and that's what I wanted to go over. The idea of trust and intimacy, such as love and affection, and how that affects various laws. So, um, of course, I'm going to be reading the book. I've got it in my Amazon shopping cart right now. And the name of that book, in case you want to know it again, Intimate Lies and the Law by Professor Jill Hasday. Okay, on trust, law, and expecting the worst. Okay, all right. And the next section. Okay, so this is our conclusion to this video. And what we've talked about are contracts such as trusts and how they are legal documents, that legal things are contracts and contracts are legal relationships. So certain relationships are considered legal, other relationships are considered natural. So not all contracts are only legal, and not all contracts are only natural. So some relationships are not governed by the legal system since they are part of natural law. And this includes or are indicated by the words we use for our natural feelings, our natural states, such as love, affection, trust, loyalty, intimacy, freedom, and belief. Trust can create legal and equitable titles, and contracts with infants is not the same as contracting for an infant. Contracts or laws that can be altered during the marriage, unless you have a prenuptial, and you can get a postnuptial, so you can alter the contract, the marriage contract. And the Harvard article, we went over that. I read it on trust, law, and expecting the worst. 133 Harvard Law Review 1963 by Elizabeth F. Emens, Emens. And the writer claims these natural laws should be within the jurisdiction of the courts, and how this can potentially cause problems since it would further expand government power. So some of the sources I used in this video are the Trust Law Harvard article, the 76 American Jurisprudence, second edition on trust, section 1 generally. You can't see that. And section 76, note 90, where it talks love and affection and title. I also talk about family trusts, a guide for beneficiaries, trustees, trust protectors, and trust creators by James E. Hughes Jr. Also, contract drafting and negotiation for entrepreneurs and business professionals, Paul A.
Swegel. And I also mentioned Family Wealth, Keeping It in the Family, also by James Hughes. And of course, a Westlaw, I think it was an entomological dictionary that I found at the law library. So I don't have a copy of that, but it's on the internet. So please like, share, subscribe. I hope you got something out of this video that helps you kind of think about things that you might want to be doing as far as writing a trust or legal documents, natural law, the legal system, and how to kind of decipher the writing within documents that you might be reading. So again, this is Jen the Liberty Lion, and I'll see you in the next video.